Hi, Karen Dice here, publisher of Mortgage Currency Magazine, and I just wanted to tell you a few of the rule changes that have occurred within the last 30 days. So this is the February 2016 update. Now, since VA doesn't issue very many circulars, I'm going to start with this one that absolutely threw us for a loop because it's supposedly been in effect for a long time, but nobody was paying attention to it. So here it is. If the spouse who is not on the loan wants to take title, they have to sign the deed of trust and they have to take title the day of closing. If the non-borrowing spouse does not sign the deed of trust, VA says it's against their rules that you cannot add them to the title after closing. Bottom line, if I were you, I'd advise the VA borrowers of this rule, and you may want to cover your know what with some kind of statement that they have to sign that you told them about the rule. In addition, VA is finally getting around to issuing their final rule in regards to qualified mortgages, but you probably want to read the FAQ number 6 in regards to the safe harbor for VA refinances. Okay, since the FHA Handbook has been in effect since September 10th, HUD is finding some issues with some of the rules. So they're now issuing what they call waivers that are added on to the new handbook. Now, in the handbook, one of the things they did, they mistakenly reprinted the old note and mortgage document, and one of the waivers says, hey, you need to use the new one, which you probably are anyway. But it's the second waiver is the one that you need to know about. It's in regards to downgrading to manual when it comes to the MIP factor on simple refinance transactions. For some reason, it's triggering a manual downgrade and errors are occurring. So what they've done is they provided a form called Request for Waiver Housing Directive, along with the exact wording that you need to use that you put in the file that says, hey, by the way, this was not supposed to be a manual downgrade, and here's the reason why. Fannie, Freddie. When it came to buying back loans, Fannie and Freddie were the judge, the jury, and the executioner. But it doesn't happen any longer because they've implemented a dispute resolution process which also includes arbitration. As a loan officer, company owner, underwriter, I can't stress enough the importance of thorough notes and explanations as to why you made that loan. The docs required, the guideline backup documents which we provide, and background checks that you've made, because this is going to be a huge asset if there's a buyback or your company is audited. And it's finally happened. Freddie has reorganized their underwriting guidebooks, hoping to make it easier for you to find stuff. So I guess the two chapters that you probably refer to most are the 4,000 and 5,000. But as a subscriber, remember, use the Ask the Experts help desk because you may get your answer quicker. And Fannie has also issued 6 new fact sheets covering different topics, but there's a couple of them that you may want to read right away. If your company is offering the HomeReady program, you'll find a new fact sheet. And the other one to review is the property inspection waiver document. You'll also find 5 other articles in this issue that might be of interest to you. So, hey, thanks for listening. And why subscribe to Mortgage Currency? Because getting a loan closed these days is rocket science.